Всем доброго дня. Меня зовут
Good afternoon, everyone. I'm Grigory Frolov. I'm Vice President of Free Russia Foundation. Today is an important day, the Human Rights Day, the 10th of December, and we, as real human rights defenders, we decided to mark this day to mark one important thing. Several days ago, Free Russia Foundation, together with Media Initiative for Human Rights and Ukrainian Helsinki Group, we submitted a petition to US government to include to the lists of Magnitsky the number of people who are connected directly to violations of human rights in Crimea. Today, we will discuss this in UCMC together with our colleagues, with Maria Tomak, coordinator of Media Initiative for Human Rights, Vladimir Rajbanko, head of the program of legal help of Free Russia Foundation, and Daria Sviridova, first deputy permanent representative of the President of Ukraine in the Autonomous Republic of Crimea. Before giving the floor to my colleagues, I would like to provide several remarks. The global act of Magnitsky, I believe, is the most efficient international mechanism to bring perpetrators to justice for grave violations of human rights and for corruption of representatives of different states. Kremlin, as it is demonstrated many times, that they feel uncomfortable. It is difficult for them to live with this, that Sergei Magnitsky's name became this banner. This name is on the banner fighting violations of human rights. I remember when the Magnitsky list broadened and became a global Magnitsky Accountability Act, and many efforts were provided, and they tried to do everything possible in order to stop this act, to take the name of Magnitsky out, because they understood that this will be a problem for them for many years to come.
При этом акт Магнитского до сих пор не был применен к нарушениям прав человека в Крыму, к людям, которые связаны с сотнями, собственно, задержанных и помещенных в тюрьмы крымских активистов, с политическими преследованиями этих людей. Как мы знаем, в Крыму, кроме того, что людей сажают в тюрьму по политическим мотивам, некоторые люди просто пропадают. В рамках данной конкретной подачи на список Магнитского мы предлагаем туда поместить несколько десятков людей, которые прямо участвовали в преследовании трех конкретных крымских правозащитников. Это Эмир Усейн-Куку, это Сервер Мустафаев, и это ключевой крымский правозащитный адвокат Эмиль Курбетдинов. И Сервер, и Эмир Усейн являются признанными Amnesty International. Эмиль был удостоен признания, является лауреатом премии Frontline Defenders. Это самая престижная премия для правозащитников, которые занимаются правозащитной деятельностью в условиях риска. Эмиль, к счастью, на свободе и под огромным прессингом продолжает заниматься своей работой. При этом и Мустафаев, и Куку находятся в российской тюрьме и были осуждены на десятки лет. Я хочу еще раз подчеркнуть, что наша подача связана именно с политическим преследованием правозащитников. И хотя мы понимаем, что в Крыму, кроме этих кейсов, существует огромное, сейчас десятки других кейсов политического преследования, мы специально включили в данную подачу именно крымских силовиков, связанных с этими тремя делами, которые являются кристально понятными для международного сообщества. Важно сказать, что, во-первых, для нас эта подача является частью большой стратегии использования глобальных инструментов и механизмов по Крыму. Несколько месяцев назад вместе с нашими коллегами и международной командой юристов мы подали огромную коммуникацию по 15 статье Римского статута в Международный уголовный суд. Эта коммуникация была связана с политическим преследованием более 100 крымских активистов. И мы очень рады, что сейчас нам удается запустить процесс по акту Магнитского. Тут нужно еще два момента упомянуть. Во-первых, мы хорошо понимаем, что в США сейчас происходит транзит власти, и мы верим, что для новой администрации борьба с нарушителями прав человека может стать одной из ключевых точек внешней политики. И поэтому мы считаем, что то время, в которое мы подаем, собственно, этих людей на список Магнитского, возможно, будет являться очень правильным и может стать отправной точкой для усиления собственно, привлечения к ответственности, расширения механизмов привлечения ответственности тех людей, которые на ежедневной основе занимаются политическим преследованием, пытками и используют другие способы для того, чтобы заставить людей в Крыму, ну, в общем-то, и не только в Крыму, молчать. Вторую вещь, которую я хочу заметить, это то, что 7 декабря Совет ЕС по иностранным делам утвердил общеевропейский акт Магнитского. И мы, и огромное количество наших коллег-правозащитников по всему миру ждали этого дня довольно долго. И мои коллеги по Фонду «Свободная Россия» Владимир Карумаза, в первую очередь, является одним из ключевых адвокатов за, собственно, за появление и за введение акта Магнитского на европейском уровне. Я думаю, что, учитывая, что мы только что подали этих людей на акт Магнитского в США, в ближайшее время мы также постараемся запустить этот процесс на европейском уровне. Сейчас я бы хотел передать слово Марии Томак, координатору медийной инициативы за права человека, которая расскажет больше непосредственно о механике нашей подачи и о ее фигурантах.
Дякую. Я, чесно кажучи, зараз не розумію, чи нас чують, чи розумію, що точно є картинка, але не впевнена, що є звук. Потім ми зможемо в будь-якому разі відео цього брифінгу поширити окремо, але мені вже мені, по-перше, здається, що це подання є прецедентом, ну, це випадок, так, але все ж таки співпраці між українським урядовим сектором суду, так, і представниками міграції з Росії. І мені здається, що саме в таких поданнях, в таких проєктах, можна сказати, наша співпраця важлива. Люди, які причетні до грубих прав людини, відчували ефект. Я трошечки розповім детальніше про подання, з точки зору того, яким чином ми вибирали тих, кого ми пропонуємо. Також озвучу
propose for sanctions, and I will show you the names separately who are on this list. And then my colleague Vladimir will
По-перше, треба
continue.
сказати,
First,
що всі
it is worth
розуміють,
noting, and you should
навіть
really
при
understand
тому, що
this,
Сполучені Штати дуже активно
the United
запроваджують
States, they
санкції
actively introduce
проти
sanctions
осіб,
against
які є
people
представниками
who are
окупаційної
representatives of
адміністрації в
the
Криму,
occupation authority.
все одно цих людей доволі багато.
We know
Навіть
that
якщо
there are a lot
дивитися
of
на
people
справи,
this,
пов'язані з політичними переслідуваннями в
cases are
Криму, на
connected with
сьогоднішній день
political
актуальні.
persecutions.
Це дуже багато справ, це
And
дуже
now
багато
there are a lot of
прізвищ, і
cases,
навіть
many names,
враховуючи те, що ми
even taking
сфокусувалися
into
на
account
3
that we
окремих справах, про
focus on
які
two
вище сказали,
cases that were mentioned
це
before.
було доволі непросто
It was
вибрати ті
not
прізвища,
easy to choose
кого ми
those
пропонуємо на
names,
санкції, так?
who
Тому
we
що ми не
propose
пропонуємо
for
всіх підряд,
sanctions. We do
хто
not
хоч якимось
propose
чином
all the
причетний
names
до
who
цих
are
справ.
involved
А
to
ми
these.
намагалися все ж
We
таки
tried to
зробити такий список реалістичний, скажімо так, які осіб, проти яких справді можуть бути накладені, на наш погляд, санкції Сполученими Штатами з огляду на, скажімо так, попередню практику. І той список, який у нас вийшов, це 16 осіб. Це як люди, які є представниками окупаційної адміністрації Російської Федерації на території Криму, так і суто представники російської, наприклад, судової влади, так, які працюють саме в Росії, наприклад, в Ростові, так, у відомому суді Південно-Кавказькому, колись він називався так, його вже перейменували, але Південно-Кавказький окружний районний суд, через який проходять, мені здається, справи всі, майже всі, по переслідуванню кримських татар, але також це суд, в якому, наприклад, був засуджений свого часу Сенцов. Так, і серед цього списку половина представників, колишніх представників українських правоохоронних органів, взагалі силових структур, які, зрадивши присязі, перейшли на сторону окупанта в 2014 році, так, і досі служать і роблять це тобто займаються, можна сказати, такою брудною роботою. Коли ми визначалися з цим списком, ми подивилися, власне кажучи, на тих осіб, які беруть участь у цих справах, і, по суті, застосували таких два критерії. Перший – це виразність, скажімо так, участі цієї особи в справі, тобто наскільки велику роль та чи інша особа відіграла в цій справі, і наскільки виразна її причетність до порушень прав людини. Це, звісно, доволі суб'єктивний критерій, так, але ми розуміємо, що санкції – це не є інструмент кримінального переслідування, це все ж таки інструмент політичний.
Political instruments. That's why we used our human rights defenders' experience while we identified the names for the list. And the second sub-criteria is participation of this person in other cases, not only concerning persecutions of human rights defenders, but on the whole. And we will speak about the list, and then you will understand that this person may be involved not only in this concrete case we are speaking about, but also involved in other cases. And this is an additional argument in order to impose sanctions on such person. I would like to show this list partly of those we identified and who we propose. These will be the representatives of the Prosecutor's Office and Judiciary. I would like to say that we are ready to send this list. We will send it to Ukraine Crisis Media Center in order to have this list on the site. And I believe now you see the list. So these are the representatives of Prosecutor's Office. Sergei Bulgakov, Deputy Prosecutor of Occupied Crimea. We added him in this list. His signature is on the official convictions concerning Servir Mustafayev and second case in Yalta case, and not only this. He is not only signing the documents, he also he signs the cases concerning persecutions of Crimean Tatar activists, for example, in the framework of cases of Crimean Muslims. He is involved not only in these two cases, but also in other cases, and this may be an additional argument. Also, those prosecutors, we also identified in Yevgen Kolpikov. He is a prosecutor of Southern Military District in the Russian Federation. He represented state prosecution in cases against Servier Mustafayev, Amira Hussein, Kuku, and Seyran Saliyev. And these are additional arguments why we propose him. He is not only a technical manager of the cases. He is not only a persecutor. He had a clear position concerning really grave sentences. Up to 20 years he proposed, and we all understand, and we analyzed these cases, and many human rights defenders analyzed this, that these cases are empty. There are no forceful actions, no grounds to say about terrorism or planning some terror acts. That's why we believe that his role should be also be considered, and sanctions should be imposed on this person because he demanded severe sentences. We know that U.S. government not often impose sanctions on judges, believing that judges, they just use legal acts and legal framework that is established by legislators, and they just operate in the system. But we focus on particular role of those judges who we believe consciously make actions that lead to human rights violations. So even in this system, they could act differently. Separate judges, and they are presented on the screen. They are former Ukrainian judges who now serve occupant bodies of power, and they carry out their activity in the framework of political cases. First is Viktor Majilansky. This is a renowned figure, and everyone who follows the situation in Crimea and political persecutions there, you all know this person. He became renowned, notorious even, in cases of Oleg Sentsov and Alexander Kolchenko. In one of the first cases, and participated in the case of Alexander Kostenko and Ilmy Umerov. Also participated in case of Ukrainian sailors. There were some preventive measures and arrests, and in the context of our submission, we would like to focus on his role concerning the case of Emil Kurberdinov, where he sanctioned de facto searches in his home, in the office of Emil Kurberdinov. And these were not searches for procedural thing, that these were just surveying, but they seized some equipment, and these computers, they contained lawyer secrets, and this was not against his this lawyer, but also against his people he defended, his clients. Among them are many who are persecuted for political reasons. Next is Anton Zukarenko. He's the judge of Kiev region court in Simferopol. Emil Kurberdinov case in 2018. He was involved in this case. He took decision to arrest Emil. This was a second arrest. Next is Tatiana Belinchuk, former Ukrainian judge. Now she's working in Железнодорожный regional court in Simferopol under condition of occupation of Crimea. And she took decision in 2017 concerning Emil Kurberdinov to arrest him for 10 days. In our submission, I would like to focus your attention on the fact that this information that we provide this is a part of information that is in submission. The text of submission is confidential. It contains delicate information, sensitive information. We do not spread it in order not to create additional threat for people. Also, these are judges that work in Russian courts. I mentioned this is a southern district military court in Rostov-on-Don in the Russian Federation. This is a notorious court that deals with the cases of Crimean Muslims. And here we focus on 5 judges who participated in cases and brought judgments. Why we submit this document? Because we have been preparing this document for a long time. I would like to thank Yulia Kazdobil, an expert concerning sanction policy. She helped us to work on these arguments, to collect them, and to write everything down correctly. And Roman Sapronov, judge of Southern Caucasus district, he took participation in case of Emir Hüseyin and also concerning Server Mustafayev. And we are speaking about Yalta case and Bakhchisaray case, as we call them. In both cases, concerning both these people, there are sentences, and it is really important in the context of our argumentation, because we from the start understood that Emir Hüseyin and Server, they are persecuted for political reasons. But before, we could theoretically say that the Russian court they could free them, but instead grave sentences were provided for them. And we may say that those judges who participated in both processes, they should be on sanction list. Roman Supranov, he headed the Judges Council, and Emir Hüseyin got 12 years in colony, and also he took participation in the second case, and grave sentence was imposed. Dmitro Merkulov also dealt with the Yalta group and Emir and Mr. Kuku case, and Rizvan Zubayev and Maxim Nikitin. Also, they were in this group of judges who dealt with these cases. They do not have Ukrainian background. They are in Russia. They are dealing with the Server Mustafayev case, and they provided 14-year sentence. And we will continue our discussion, and I will be able to say more. But lastly, I would like to say that we believe that Ukraine should more actively use the instrument of the Magnitsky Act in different variations. Grigory mentioned about European Magnitsky Act that was voted for this week in the framework of the European Union. Also, there is a British Magnitsky Act legislation for imposing sanctions on those who violate human rights. In order to make such submissions, resources are needed, understanding of legislation is needed, and the proper approaches should be used in order to create such lists. So we may provide this submission also to Europeans, but I remember what is going on in France and legislation that will appear soon, we believe, and the social situation there, and stories about terror acts and the connection as they see it and how it is will be presented in legislation, maybe they will establish some connections with radicalism, and the submission is focused on human rights defenders, and they try to say that these human rights defenders are extremism. I do not see whether they will be able to support here now in France. So those are. Maybe we should focus on other cases when we are speaking about Europe. We believe that in France, as of today, they won't provide big support for this submission. We believe that our submission, this submission, will be supported politically by Ukraine, the government of Ukraine, and we understand that probably we, of course, should have some public campaign. Without it, we won't be able to promote this submission. That's why we hope for support of the embassy of Ukraine in the United States, and we would like to have the support of the Ministry of to join the argument that Ukraine should actively participate in this mechanism. I believe that the Magnitsky Act should be transformed into people's law. Not only Artem and Chaika, top officials should be included, but also as it was created that there should be law enforcers at local level. They should be included in this list. Those who persecute politically activists, journalists, human rights defenders, and others. We will go back to legal sphere, and I would like to give the floor to Vladimir Shpenkov, and he provides legal help in the framework of Free Russia Foundation. I believe that Vladimir has something important to say. Thank you. Many people in society, they do not believe that this means is efficient. That's why I would like to speak about the concept of sanctions, international sanctions, and this type of influence on perpetrators in current conditions that we face. The concept of sanctions, international sanctions, that it is envisaged by Magnitsky law, and we wrote our document in this framework, and this concept was formed in 1990s, and more than 30 campaigns passed by, and they were all successful. Usually, these campaigns take more than 10 years, but this is the most efficient way of non-military influence on perpetrators and the perpetrators of the international laws. Sanctions. There are three main positions. First, this is stop to perpetrators' activity, also compensation of losses, and third, and the most important, is prevention of illegal actions. It is important to prevent such actions that are outside the scope of international law. And in our case, this is about human rights. To introduce those people in sanction lists, this is not an attempt to just to punish them. The main is to prevent others to deal with these things, to prevent such actions that were committed by those who were included on the list. Second, personal sanctions we are speaking about now, imposition of sanctions on separate individuals who committed grave violations of human rights. So there are sectoral sanctions imposed on spheres of economy and industry sanctions on different sanctions on different industries. So our document follows the logic of the Magnitsky Act. First, we consider people who directly involved, those people whose rights were violated, and people met these people personally, and then we go up. And the compiling of such documents shows not only that there are separate cases of violation of human rights and separate cases, and I will list them, and it shows that there is a systemic campaign organized, centralized, and they have a strategy of suppression of some type of behavior and has the aim to suppress legal expression of opinions, political positions, convictions that this occupant state, for some reason, believe unacceptable. So this is the theoretical part. Now I go to the practical part of our document and persons who are included. And I would like to show how this concept is implemented. I would like to follow the example of Maria and to share my screen. 1 second, please. Maybe you now see what is on the screen. My part will concern those people our human rights defenders met with. These were the first people they saw. This is the Ministry of Internal Affairs and Federal Service of Security, FSB. Center Air, this is extremism, the Center on Fighting Extremism. In current criminal code of Russian Federation, there are many articles concerning extremism, and the definition of extremism there. This is a secret question, and this is an article. You can cover any action by it. And so this article is in latest, and Center Ed deals with extremism, and FSB deals with terrorism. And extremism and terrorism, they are not properly differentiated between themselves. First, they try extremism, then they reveal some facts that show that there are signs of terrorism, and then FSB is included. And this system works. First, the person is in a pretrial detention facility concerning one case, then the time expires, and then the second case is started, and then he is really close to those people. With those people who are included in our document. So then there is a court hearing, and then people go to colonies, and colonies are in remote places. And in this case, these people, they really they put these people closer to repressive bodies due to this transfer of cases from center of the Ministry of Internal Affairs to FSB. First head is Mr. Utkin, and he develops the strategy of persecution, and he is responsible for how and in what oblast they will put this nets of repressive machine. And due to his decisions, people early in the morning, even when it is still dark, they hear that the doors of their house is broken, many people enter without any insignia, and people, they are terrorized for many years, and this is all due to Mr. Utkin. Center A, we have here bright representatives, Ruslan Shambazov, and he is in many cases concerning persecutions of human rights defenders, activists. He personally coordinated torture, personally participated in torture. He used many initiatives against these people. He should be included in those lists. He deserves this completely. And I believe that these people will be included in the European sanction list because, based on results of the activity, we see that many people really suffered and became the victims. And as Mr. Frolov said, it is crystal clear example. There are many cases concerning this, and these individuals actively participated in those cases. Also, some powerful organizations, such as Federal Security Service, head of department Leonid Mikhailuk. This is a person who coordinated, on the whole, all the policy concerning repression of those who do not think alike, those who fight against all opinions that contradict the opinion of the leadership, and the complex, systemic, comprehensive campaign to pressure and force people in the territory of Crimea. And all the strategy is done by him, and he also compiles the reports. And also there is concerning the Serir Mustafayev case, also who dealt with this case. So this case went to political level. Second one is Alexander Kompanitsev. He directly participated in Emir Hussein Kuku case. He directly participated in massive acts of pressure and also acts of violence, and he is one of the bright representatives of the Department of FSB in occupied Crimea. Before he served in SBU, and he betrayed his country. Sergei Makhmudov and Dmitry Ramashev these are investigators who dealt directly with the cases, and those people who interrogated people, and they also wrote the documents based on which the people were sentenced. So these are not just some people who implemented these cases. They provided their own initiative in the cases. They made these cases more grave without any necessity, and these are bright representatives of repressive system of this machine that is active in the occupied Crimea. Thank you very much. My speech is over at that. Thank you, Vladimir, for this. And I would like to give the floor now to Daria Sviridova, First Deputy Permanent Representatives of the President of Ukraine in the Autonomous Republic of Crimea. I have a question that is really difficult. First, about your office. People that who deal with the violations of human rights in Crimea, and also your opinion about prospects of development of Ukrainian legislation concerning those sanctions in order to make Ukraine more logic in the context of global sanction policy concerning Russia and separate perpetrators of human rights. Good afternoon. You've done, it is really important. I can only imagine this huge work and the expertise needed to prepare the submission. Of course, we cannot respond for all the bodies of power of Ukraine, but the permanent representative office, we monitor the situation concerning violations of human rights in the occupied Crimea, and we have systematic focus on these issues. In the framework of these events, we do it in the international arena as well. And the instrument of sanctions is really important to observe human rights and to create conditions to stop violations in the territory that was occupied. And this is non-controlled territory because it is occupied by the Russian Federation. If you're speaking about the persons you've mentioned in your submission and communication, I would like to know the importance of the topic concerning human rights defenders who are persecuted in the occupied territory. This is a separate category of people who need special protection, and there should be proper recognition of conditions of their work. These are not just words, these are norms that are recognized at the level of the Council of Europe and UN structures. And I'm really glad that you focused on these categories of people who are persecuted by the occupation authority. And among people in your list, you mentioned the lawyer, you mentioned Ilkur Bedinov, maybe everyone knows, and for those who do not know, I would like to say that there are main principles concerning lawyers that are approved at the level of UNO, and they say that any state should provide for conditions of work for lawyers, that the lawyers be able to carry out their professional responsibilities, and they should be free without any intimidation, persecution, and what Russia does shows that the occupant country does not adhere to these principles. And the fact of occupation does not free the country from adherence to these principles. And now the lawyers are unique defenders because there is no access for international missions and enforcement bodies of Ukraine. And I really greet you with this, that you focus your attention on human rights defenders. Also, we are dealing with these issues of persecutions of our citizens in the territory in cooperation with the Ministry of Foreign Affairs and the law enforcement bodies of Ukraine. We're working on raising these issues at a higher level and introduce sanctions against officials in the Russian Federation and about citizens of Ukraine. Without doubt, Ukraine should bring those people to responsibility in the framework of criminal cases for persecutions of our citizens in the occupied territories. So your submission and about the sanctions concerning these people and the use of sanctions by international partners, I believe that this is really important work that should help protect our citizens in these occupied territories. About legislation, your second question. There should be our legislation concerning sanctions is far from ideal. And experts and state power understand that, unfortunately, legislation that was adopted at the start of the conflict, it is not efficient, it doesn't work properly today. Recently, there were committee hearings in the Verkhovna Rada concerning improvement of sanction legislation. And last year, or the year before the last year, there were committee hearings to improve sanction legislation in the context of bringing to responsibility to impose sanctions on those who violated human rights in the occupied territories, and to focus on these people directly. And a lot of issues are raised concerning necessity of synchronization of legislation and sanctions of international organizations, introduction of the Magnitsky Act here. This issue is not resolved at the legislative level, but now discussions are more loud, we may say so, at the level of the bodies of our power, not only among experts. And today we have a working group in the framework of executive bodies of power. And now we want to harmonize our sanction legislation in order that our sanctions be efficient. For this, we need to improve the mechanism of the sanctions and to monitor quality of these sanctions. And there is no responsibility for violation of sanctions in our legislation, and this is in the focus of attention of the bodies of power and in this interdepartmental coordination that is now being built among the bodies of power, both executive and legislative. We hope that we will be able to improve our legislation, and when we address international partners, when we ask our partners to introduce sanctions against physical persons who are involved in violations of human rights in the occupied territory, this position should be reinforced by our own efficient sanction legislation, and we should have a proper mechanism to persecute such people, and this is really in the focus of our attention, including our office. I believe that we have several minutes. Maria, do you like to? And it was mentioned before, there are things that do not depend on legislation. For example, activity of Ukraine in promotion of some names using the opportunities of the Magnitsky Act in different countries. In order to do it actively, you do not need to change legislation. This should be like a machine that monitors the situation in Crimea on a permanent basis and provides submissions, lists, arguments, and this should be a continuous process in order that people who are involved in these violations, they should feel right away that this is recorded, and this may have an effect at once. Maybe this effect is not a big effect. For example, like Shambazov won't go to US or Switzerland to open an account in some foreign bank. But I would not come to this preliminary fast-made conclusions. And the liberal communities and Russia Federation, we see that there is many hypocrisy, and those people, they have some assets in foreign nations. So I would like to say that one of the reasons why we submitted the document to U.S. government, American sanctions, they are the most painful. Even those sanctions that will be introduced by the European Union, they won't be so efficient as the U.S. sanctions, because this is the first economy in the world. This is like this. Maybe Grigory will tell you more about this, but I would like to invite all the viewers to join us at 5:30, and you will tell us about it. And Yulia Kazdobina, one of co-authors, will join us. She deeply understands the issue of sanctions, and she will be able to provide more information for in-depth discussion, because now we are having such an official presentation, and then we will be speaking about opportunities to introduce sanctions against such. Of efficiency of promotion of sanction policy in different foreign nations. I believe that we should not be so skeptical about this. We clearly understand that many representatives of Russian state, they like to speak about patriotism, but they like Italian beaches. Miami is not for everyone, and Italy is good for law enforcers. It is easier for them to get there. That's why we shouldn't discount the European Magnitsky list. And I would like to say that At 6:30 there will be a conference, and please join us. Please join us during this discussion, and there will be more time for asking questions, and more information will be provided to you. Thank you very much for being with us today. I greet you all once again with International Human Rights Day. Have a nice day.